Welcome back to another J. Harris Academy of Police Training Roll Call. I'm Joey Sperlazza. Today we're going to be discussing State v. Harvey Cutts. This is a recent decision out of the Appellate Division, New Jersey, decided on December 11th, 2024, and it discusses Terry stops and frisks. This is an unpublished opinion, but it sets forth a lot of facts that we already know related to stop and frisk. Number one, for us to stop an individual, we have to have reasonable articulable suspicion that that person has committed or is about to commit a crime. That stop is independent of the frisk. For us to frisk somebody, we have to have reasonable articulable suspicion that that person is armed with a weapon that can compromise officer safety. So let's get into the facts of the case. Following his denial of his motion to suppress evidence, including a handgun seized from him during a pat-down of his person and then search incident to arrest, the defendant pled guilty to second-degree unlawful possession of a handgun. He now appeals the motion. On November 21st, 2022, around 8 p.m., officers of the Narcotics Gang Unit were conducting an operation in the area of Leonard and Federal Street in Camden. This area is known as an open-air drug market for recent shootings. They have also received information from a confidential informant. Officers observed 4 males wearing heavy dark clothing and ski masks standing on the north side of Leonard Street. There were 2 males at the other end of the street. Officers observed a heavy amount of foot traffic in the area leading to the 4 males. After observing pedestrians coming to the set, officers approached the 4 males. One of the 4 males concealed himself in between 2 cars and immediately broke contact. The males would normally have been charged for loitering, however, no such charges were filed against the defendant. Marked police units were notified to conduct stops. As the marked cars drove down the street towards the 4 males, the males bladed their bodies away from the police car. Based upon these actions, officers believed the men might be dangerous. The 4 males, including the defendant, were detained and handcuffed. Several factors, such as recent violence in the area, poor lighting, foot traffic coming in, one of the males breaking off, and one of the males concealing themselves in between cars, led to the investigatory detention of the males. All 4 males were frisked when they were detained. The testifying detective stated it's common practice for an officer to frisk an individual being detained. The frisk of defendant resulted retrieval of a Glock 26 firearm on the defendant's person. He was arrested and search incident to arrest was conducted and revealed narcotics. A search of the surrounding area located narcotics and a firearm on the front driver's side tire of a Hyundai parked approximately 7 to 10 feet from the 4 males. The defendant was not charged with possession of these items. The trial court denied defendant's motion to suppress. The court found that the testifying detective was credible. The court concluded that the totality of the circumstances, including observations of the males in an area known for narcotic sales, arrests, and a recent shooting, provided officers with reasonable suspicion of criminal activity and belief that the defendant was armed and dangerous. The court found that the blading by one or more of the males very significant. The court concluded that the suspicious activity, coupled with the blading when patrol cars approached, justified an investigatory detention and frisk. While the 4 males were detained in handcuffs and frisked, officers searched the vicinity. Within proximity to the males, officers found a gun and narcotics stashed on the tire. The defendant was not charged with any criminal offenses relating to the gun and narcotics found on the tire wheel. The defendant appeals, arguing that the police stopped him without a valid reason. The police did not have reasonable and articulable belief that the defendant and his 3 friends were involved in criminal activity, and blading did not provide reasonable suspicion to believe that any of the 4 men were armed and dangerous. In analyzing the totality of the circumstances leading up to a stop and frisk, New Jersey Supreme Court has recognized that the reputation of an area may be relevant to the analysis. However, the court has also held that just because a location in which police officers are dispatched is a high crime area does not mean that the residents in that area have lesser constitutional protection from random stops. An investigatory detention is intended to be a relatively brief detention by police during which a person's movement is restricted. It must be based on an officer's reasonable and particularized suspicion that an individual has just engaged in or is about to engage in criminal activity. Determining whether reasonable and articulable suspicion exists for an investigatory stop is a highly fact-sensitive inquiry. The next inquiry focuses on the lawfulness of the frisk. Terry permits a law enforcement officer, for his own protection and safety, to conduct a pat-down to find weapons that he reasonably believes or suspects are in possession of the person he stopped. To conduct a frisk, the officer must be able to point to particular facts from which he reasonably inferred that the individual was armed and dangerous. Here, there was no specific information linking the defendant to recent shootings. The defendant did not engage in any particularized behavior that would lead officers to believe he was engaged in criminal activity, such as seeing defendant engage in hand-to-hand transactions or furtive gestures. The defendant did not flee the area as officers approached him and restrained his movement prior to being handcuffed. While officers were familiar with the area and had conducted narcotics arrests and knew of other narcotics arrests made in this area, there was no testimony about the defendant's criminal history. The area was also a residential area. The Supreme Court has held, while reputation of an area may be relevant to the analysis, it does not mean that the residents in that area have lesser constitutional protection from random stops. The officer's observations that evening must be viewed through his lens as an experienced and trained officer of NGU. The suspicious conduct included an unspecified number of individuals described only as heavy foot traffic in an area where narcotics arrests had been made, and this foot traffic led to the 4 males standing on the street. One of the males was seen concealing himself between 2 unknown cars and immediately breaking contact. There was no testimony as to how long officers observed the males, the approximate number of pedestrians in the area, or how many approached the group, or whether the defendant was the individual who went in between the cars and concealed himself. There was no testimony regarding any observations of hand-to-hand transactions. Prior to conducting the investigatory detentions, officers did not approach the males and engage in a field inquiry. Rather, officers immediately detained all 4, including the defendant, in handcuffs. Aside from the defendant's presence on the street that evening, none of the defendant's behavior was indicative of criminal activity. Even if the court agreed that these facts provided RAS to justify an investigatory detention of the defendant, there was insufficient evidence to support the conclusion that the defendant was armed and dangerous. Furtive movements without more is insufficient to constitute reasonable and articulable suspicion. Frisking a person as commonplace practice goes against existing case law. The totality of the information did not amount to an objectively reasonable and articulable suspicion that the defendant was involved in criminal activity or that he was armed and dangerous. The state failed to establish RAS to stop the defendant or frisk him, and the trial court erred in denying the motion to suppress. Motion to suppress granted, case remanded for further proceedings. We have to establish a particularized suspicion for each individual. These people have their individual rights. Though as a collective group, you may be able to detain them, you have to have particularized suspicions for the individual that you are patting down. By having an overly broad police report or an overly broad testimony about a group of individuals, it may not justify the frisk of that individual. Blading in itself is being treated as a furtive movement. Furtive movements are not enough to establish RAS. You have to describe exactly what that suspect was doing. He bladed his body specifically by stepping back with his perceived dominant hand, as if he was trying to conceal an object, by pinning his right arm down against his side. That would be a way to particularly describe a blading movement that could give rise to RAS. But the description that was given here of just blading, just being in a high crime area, it was not particularized. The court very well established in State versus Goldsmith that we're going to scrutinize these high crime areas. The people that live in an impoverished area, even if it's a boarded up home, if that's how they choose to keep their home, that is just as constitutionally protected as a Beverly Hills mansion. And that's something that we have to remember. If you want to learn more about these types of stops and these types of cases, I encourage all of you to take our Road Cop Essentials class. The report writing class that we teach also goes into these fact-specific details to ensure that you're articulating these points very well. And for the supervisors out there, if you're reading it, we need to make sure that it's not overly broad, especially in these cases where we have multiple people stopped. So I look forward to our next roll call. Again, I'm Joey Sperlazza. Stay safe.